arbitration becomes a ground, then it will also be a ground that the lawyer is busy in some other court doing some other litigation. That per se, again, uh, referring it to some reflection on what Jimmy said, that lawyers feel that it is my duty, I should have everything at my. I will do arbitration also, I will appear in this court also, I will appear everything. Now, I am a very strong believer that give some space to your colleagues who are more focused. There is work for everyone. And I'll reply to Jimmy's question that he says that I totally agree with him. I tell you my experience. It's slight digression, but I think it is important for the audience to know. I'm talking from experience. No bookish knowledge, nothing. All from experience. When I was elevated, there was a group of cases which was really very financially important. Because I was elevated, decided to go to someone else. The client came after 1 month and he told me just to wish me all the best and friends. By the way, I asked you what happened to that case. I hope you are taking care of it because it's very hotly contested. The stakes are very high. He said, no, sir, I've interested that brief to a lawyer. Or was known, but it was quite a middle level. Out of curiosity, I said, Ki, you are aware of the seriousness of the issue and due to state surveillance. What prompted you? You know what he said? He said, I asked my colleagues, they said, go to him, he will get the matter disposed of in the High Court in 6 months. Not bothered about what would be the. He knows there's a forum. He wants it to be disposed of within 6 months. Now, time is of the essence. Everybody has realized it is better to know your result within 6 months, whatever option is left, so that you give a finality. That is also to be remembered. It is one of that case got him so many clients and big clients. You dispose it of people. It's a myth that I have to keep holding on, especially the lower courts. It's a myth. The moment you get your matter decided, 10 more will come just because you are a lawyer who promptly gets matters disposed of. Now you have to change your mindset. You are not in sync with what the clients, the litigants see today, being pressured by litigation. And again, back to your point, Mr. Singh, in that case, we have created a special ground for adjournment. A lawyer, a counsel may be involved as a third or fourth counsel in a litigation. It's been very easy because we know that this is a ground now universally accepted by the court for adjournment. You just understand the pressure judges are in. The media, one unnecessary adjournment, the other side, yes, if both sides agree, we have absolutely no issue. If the other side disagrees, it should have been long. If there's an interim, I weigh a lot of factors before sealing or refusing. Normally, I don't refuse, but if these factors are there, long time stay, I have to weigh. My job is having a balanced, level playing field. Nobody has the vaguest of the idea what goes through a judge's mind, what responsibility. You have to sit in the chair to experience. Nobody has the vaguest idea in the entire audience or the intellectuals. What is upon the judge when he is really sitting as a judge? It's very different. It heard that.
Unix, what I said was slightly on the point that when dates are being given, look for the adjournment. When dates are being given, suppose court says that 21st of July is the next date. What we say, if I said that kindly have it some other day, day after, because I have a hearing on that day. That is the point I was trying to make.
I am totally with you. In fact, I prefer, I ask the counsel where there is a hearing, a really hearing required. I tell them, you choose your dates. I tell them, both of you decide. I have to come here on all working days. You tell me your convenience. I have no preferences. Do decide, but then on that day, you have to be honorable. I practice that and I keep preaching that. And after hearing from you, I'll now propagate it also.
Thank you very much, Mrs. Manula. Now, since James is joining virtually, may I request the organizers to set him up? Oh, hi, James. Hope you can hear me. Yeah. Good to see you, go virtually. James, so we are running sort of time, so I'll quickly ask you about importance of being perceived as a safe sea of English. What are your takes on that? Can you quickly tell us, Boris?
Yes, absolutely. Before I do, let me just thank Mr. Aaron Chalpa, the strategy Kaxan, panelists, list, calling else for not being there in person, but I'm grateful for the opportunity to participate. So I think to address your question specifically, um, in the context of our panel, university this is a seat is critical to attracting foreign investment. Right? It is nothing interferes now in events in the U.S. As to how important that is, because when you're perceived as a seat that neither affects the process or that has excessive judicial interference, or where the rule of law, which we heard a lot about in the first panel, is not always respected, it becomes incredibly hard for businesses to predict how things will go, how disputes will be resolved, and what will happen to their investment. So I think me perceived as a safe seat, which you touched upon earlier, a seat that has a strong judiciary, but one that respects its role with the whole process of ADR. It's a clear arbitration, one that will avoid interfering unnecessarily, one that will offer support when it is needed, and one that will help keep the process efficient is really critical. And I would simply point out here that that is something that India has made incredible strides in over the course of my career. When I first started practicing 20 plus years ago now, my first matter in India was a matter in Bhubaneswar that went on for a very long time. Um, Similar to how things were going in any jurisdiction, frankly. But over the course of the time since that matter to now, you have seen an incredible run of pro arbitration case law come out of the Indian Supreme Court. You've seen much greater confidence in India as a seat and in the Indian judiciary, and it's incredibly lawful. So much so, in fact, that I think many jurisdictions that are counted as preferred seats around the world, including New York, could take a page from that playbook. So that's a very summary answer, but I think it's the best one I should give.
Thank you very much, James. So now we move on to Shweta. And Shweta, we know we are running out of time, but we need to have your quick insights on how do we make our arbitration ecosystem in India more robust. Kindly share your experiences.
Whenever this is Manipula, Mr. Rapun Singh, Jimmy, Ila. Good afternoon, dear friends. James, we are not able to see you, but we can definitely.
Shweta, can you bring your mic closer?
Yeah, I think now I'm audible. So the issue that actually is raised is very important, and with the first session that we heard, we realized that there are challenges of arbitration because of which we are looking at mediation as an option. Why have we reached this stage? Where have we gone wrong? And what are the corrective steps that are required to be taken is something that we need to really do an analysis of. I think the first step that we need to understand, and I think I would straight away jump to what I have to say, is if we have to focus on dispute resolution, we have to understand the need of the business. If we look at the stakeholders in the process, we have the lawyers, we have the general counsels, we have the judiciary, we have the arbitrators. I think between these four key pillars rests the whole responsibility of running the dispute resolution process. Now, because the courts are already overburdened, there are almost about 5 crore cases, which is about 50 million cases that are pending in courts. Definitely, we need to look at appropriate or alternate dispute resolution mechanism. And that is why we started with focusing on arbitration. From 1940 to 1996, we saw that 1996 Act was more to adapt to the requirement at that point of time. But from 1996 to 2015, there wasn't much progress in terms of legislative amendments. From 2015, we realized where we are going wrong and we corrected ourselves in 2019 and then in 2021. And we did not stop at that. We now have a 2024 bill as well, which is pending. So, which means the legislature is understanding the need for making amends wherever necessary. So, that is one step which has been taken into consideration. Why are we still not able to speed ourselves up? And if we look at the pattern in terms of the judgments that we have seen, the judgments when we started in Renu Sagar in 1994, it gave a certain direction to the entire arbitration framework. From there on, I don't know where did we go wrong in Bhatia. And then we further went wrong in Sopives and then in Western Indigo. We started to correct ourselves from Balco. And we have now reached the stage where we are talking about Gayatri Balasamy. I think we have covered a lot of ground so far as the judiciary is concerned. But is that enough? I think where the problem lies is the fact that dispute resolution topic is being discussed only between dispute resolution lawyers. The first person or the set of people who need to understand where the challenges lie is the transaction lawyers. I think Jimmy mentioned about it, but it is the transaction lawyers who actually give us the feeding ground to have disputes which go on forever. Whether it is about change of law, whether it is about governing law, whether it is about force majeure, I think these are some of the very important issues which are left as a boilerplate clauses, never bothered to be understood, and therefore we keep arguing about all of those clauses forever. So I think the first change that we need is with respect to including transaction lawyers in the discussion which is happening with respect to dispute resolution. The second element of the lawyers who actually need to also understand, and it is crafty lawyers who are sitting in this hall, who also find ways and the means to find lacunas in the whole agreement and then try and delay the whole process. Arbitration in today's time, at least I have come across most of the arbitrations getting over in time. Where are we facing the real challenge is when it goes to the court in section 34. Then it goes to the further concern where it goes for enforcement. I think Ila is going to touch upon enforcement, and I'm not expressing my pain points around enforcement, but there are just way too many. In section 34, we go on forever. There is no commercial mindset that the judiciary has to understand the requirement of the whole, the ecosystem. And that is where it starts to falter. Then it goes into 37 and then goes up to Supreme Court. And in Supreme Court also sometimes up to curator. So we are not putting an end to the process. And it is not just the judiciary to blame, but also us as lawyers, because we are not putting finality to a process. We are finding ways to identify the lacunas and then to go on forever in that regard. So I think the first category of people who need to understand this concern and instead of talking always about arbitration is to ensure that it functions in the manner in which it is envisaged. The second, of course, is the general counsels, because general counsels also need to understand when they are looking at the seat or looking at which are the appropriate jurisdictions or looking at the dispute resolution clause or the institutions that they have to decide on. It is at that point of time also they do not apply their mind. Most of the clauses that are mentioned do not have institutions still mentioned. I do not understand why even after so many years of the institutions doing so well, are the general counsels not able to trust the institutions that are functioning? So I think we need to institutionalize arbitration as quickly as possible. The third element is judiciary. I've already spoken about it and I would not want to go on talking about it, but then there is definitely a need. And this is where probably I think that there's a need for also doing a capability or a capacity building. Because for us, sitting in Delhi and Mumbai, it is much easier to talk about all of this. But if you go further down, maybe just 200 kilometers outside of Delhi or Mumbai, you will see that to be a completely different environment. So I think the need of the hour is to do capacity building. We look at specialists to get into onboarded as a judge, And those specialists who have a specialization in arbitration is then given a criminal roster. So I think our roster system also needs to be relooked. We need to understand how we are able to best utilize those who have a specialization in certain areas of practice. And most important is the arbitrators. This is not a pastime. This is not a part-time exercise. This is a very serious commercial discussion that is happening. The adjudication that has to be done as seriously as you have been doing the matters in court. This is not the civil courts where you have to go on with a civil procedure to be followed. I think that's also where we are faltering because it just is a never-ending exercise when it comes to arbitrators. So training of the arbitrators is equally important. There has to be some kind of a continued legal education even for the arbitrators. To become an arbitrator, you need to have a certain amount of accreditation, and I think Mr. Ratan Singh mentioned about it. It is a very good exercise that is required to be done. It will be much easier for the lawyers also and for the clients also to be able to identify which are the best, arbitrators with respect to certain areas, and then be able to focus on those sectors, expert arbitrators. So I think let's focus more on capacity building at all stages, whether it is lawyers, whether it is judges, whether it is the arbitrators. I think that is going to really change, bring a paradigm shift that we are looking at in terms of making arbitration or India an arbitration hub as we talk about it, and also focus on the arbitration in the era of globalization. I think that's the real concern for us, and we need to address it as soon as possible. That's my 2 bits. Thank you so much.
Thank you, Shweta. Just to add to what Shweta said, one thing which if arbitrators will start doing in India, it will immediately end the old conduct of arbitration system. One, the moment files, papers, documents come before the tribunal, they should make efforts to go through them. What happens in India is typically in all international arbitration, first day arbitrators will tell you that, ladies and gentlemen, you should take it that we have gone through the file below the records. Somehow we are not doing it in India. Files are opened by the arbitrators at the time of final appearance or maybe at the time of writing of powers. Not good. If you are not, if you do not know the dispute, you can never be in the control of the proceeding. You can never decide the discovery applications. In cross examination, you can never get your doubts cleared. You will otherwise just keep correcting the grammars in English. That is not how cross examination is meant for. In cross examination, the tribunal should get their doubts cleared rather than simply observing that whether a particular question is asked in a particular manner or not. So that is one thing I thought I must. Now we are running short of time, and I am now going to Ila. Ila had said that I have very quick thoughts to share on enforcement. So now heading to Ila on the quick thoughts on enforcement.
They were quick to begin with, but given how late we are now, they'd be even quicker. Um, just very quickly, everybody on the panel has spoken about the challenge of delay. But before I get into that, what do investors want when they're looking to invest in a country? They want a neutral forum, they want enforceability of their awards, and they want it to be insulated from the courts. How are we doing in India? What is our report part here? Well, I think our arbitrations are obviously now much quicker. We have had many amendments to the Act. We have a lot of pro enforcement jurisdiction coming from the Supreme Court, which has helped in perception of finality of the award, starting at Vijay Karya cases which show that they are not going to go and sit on a beam. We have Supreme Court judgment which even helps us with technical delays in derailment cases where they say when, for example, stamp duty is not going to be an incurable defect. We're sort of ahead of the curve in recognizing enforcement of emergency decisions and interim relief. Many jurisdictions haven't done that so far. So that's all our positive scorecard so far. What is the problem? What's the real problem? I feel when we represent our clients, well, the simple answer is show me the money. You get the award, we never are able to execute. We are stuck in court for people on this panel have spoken about the reasons for the delays. We all know that delay is endemic in our court system. After we get an award, we are back to the same situation as if we had been in a litigation. I have a case where I'm representing a Korean client. We were able to get an award in a Singapore seated arbitration In 2 years, we were able to pass it through the courts, get finality there. But it's still 3 years in the Bombay High Court where we haven't been able to get it for a jurisdiction where we see it at that stage. So for the Korean client, it doesn't matter that he got his award very quickly. He hasn't seen his money, and it's not looking like he's going to see it anytime soon. Some decisions, which may have been very specific to the facts of their case, such as VMRC or Gayatri Balaswamy, the problem with those decisions is that they leave a sort of impression or a precedent where parties don't want to accept that their award is final. They will keep on going to the next round, the next round, the next round of challenge in the hope of a modification or in the hope that, finally it gets set aside. Especially true, as we all know, for government entities and government sector undertakings who don't want to take that decision to settle. One of the biggest things I tell a party, a foreign client, an investor in India, well, you won this big award. What is the next step? And I will say, well, now settle. Don't wait for this to go through the courts of execution. Now settle because it's worth it. It's going to save you years in courts in India, and you may not see your money. So settle, discover where the assets of the other party are, try and get funds deposited court, try and get interim relief. And these are the grounds that I think council should use more and more rather than belaboring an already very delayed system and going through the courts and going through that delayed process of enforcing. So was that quick, Ratan?
It is really the quickest amongst all of us. Thank you, ladies and gentlemen. Uh, I think we have something to talk about after this session on what all we have spoken. And Melodis Hamanullah will have the last words on that.
Thank you so much. It's been really exciting and thought provoking. To see things on the practical aspect, Mr. Ratan said that judges they have to decide, so they should be experts. I slightly deviate from the main path. Point is taken that the person who decides should be really well versed with the facts. He should be an expert. So that may be more applicable to the arbitrator, because now you don't put that condition to the arbitrator, but in the judge you would want that to be. Basically, 80% of the arbitrators in India, the fact is there, are judges, ex-judges, former judges. So you have to first enforce and see that the person before whom you go, he sashes out at a very, very deep understanding at that level so that it is less open to challenge. Once you ensure that, I think a lot of your problems get solved at that stage, because a lot of things comes filtered. Because that person himself is not qualified to be the arbitrator in the sense you would want him to be, typically well informed and expert on that subject. The result is there are many points which are left open for the courts to consider, or at least give it a thought. He may not ultimately hold, but then it creates time, it takes time, the system suffers, the credibility suffers, the faith suffers, the confidence comes down. So you have to plug the hole at the level of who the arbitrator is. The other thing is that counsels are representing both the parties before an arbitrator. Rarely it happens that the client himself or herself argue, or the institution through their internal resources. Both sides are advocates. So you have to sensitize your fraternity who is expertising. Now this has become an expert domain of counsel expertising only in arbitration. Them they have to be more responsible that look here frivolously we will not file an appeal. How what do you do that? You have to target that. I'm being on a very practical and basic level if this things are to succeed. Otherwise we keep holding this session and the result would be yes, a weak gray area, weak area, a little bit step forward, step, baby step forward. That doesn't improve. That doesn't give an impetus to this system. Now coming to the uh, enforceability and finality. I think the moment a client understand that this is will give it a finality, that is the biggest confidence building, and that is for the system, especially the persons who are really administering. And here my specific pointed finger is at the council. They are the persons who really control the system. Where to go, what to do, what issues to raise, which forum to choose. It is they who are controlling even the courts. They approach the court, and before the court, you forget. A judge may be very sensitive, but he cannot be technical. He has to give a